Judiciary and Civil and Criminal Jurisprudence Committee will now be called to order. Mr. Secretary, please call the roll.
Senators Schroer.
Here.
Gregory 15. Brown 26. Berger. Here. May. Roberts. Here. Schnelting. Here. And quorum.
All right, we have a quorum. I now move that we go into executive session. Do I have a second? Second. Having a second, we are now in executive session. I now move that we bring up Senate Bill 945 and, do I have a second? Second. Having a second, Senate Bill 945 is now before the committee. This was Senator May's bill on the circuit court, allowing them to collect a no more than $15 for maintenance of the law library on every civil case filed. This has been around for a number of years, dating back to 2020 or 2016. Do we have any discussion? Hearing none, I now move that we do pass Senate Bill 945. Do I have a second? Second. Having a second, Mr. Secretary, call the roll.
Senators Schroer.
Aye.
Gregory 15. Brown 26. Berger. Aye. May. Roberts. Aye. Schnelting. 4-0.
Our vote of 4-0, you have due passed Senate Bill, whatever that was.
945.
945. Now moving to Senate Bill 1140. I now move that we bring Senate Bill 1140 before the committee. Do we have a second? Having a second, 1140 is now before the committee. This is the bill on civil action for recovery of damages suffered as a result of childhood sexual abuse. This is by Senator Hudson. It's been around since 2023. Do we have any discussion on the House or Senate Bill 1140? Hearing none, I now move that we do pass Senate Bill 1140. Do I have a second? Mr. Secretary, call the roll.
Senators Schroer.
Aye.
Gregory 15. Brown 26. Berger. Aye. May. Roberts. Aye. Schnelting. Aye. 4-0.
By your vote of 4-0, you have due pass Senate Bill 1140. Now move that we bring up Senate Bill 1392. Do I have a second? Having a second, this is now before the committee. Senate Bill 1392 is allowing for changing the criminal statutes when a person commits the offense of murder in the first degree if he or she knowingly delivers or distributes fentanyl or carfentanil or any derivative thereof, and a death results from such use. This has been around for a couple of years. Last year it was Senate Bill 531. This year it is Senate Bill 1392. Any discussion? Seeing none, I now move that we do pass Senate Bill 1392. Mr. Secretary, do I have a second? Mr. Secretary, call the roll.
Senators Schroer.
Aye.
Gregory 15. Brown 26. Berger. Aye. May. Roberts. Aye. Schnelting. 4-0.
By your vote of 4-0, we have due passed Senate Bill, what was that one? 1392. I put all my notes away. I now move that we move out of executive session and move to public hearings. Do I have a second? All right, we're now in public hearings on the first three bills will be presented together. It's going to be Senate Bill 882, Senate Bill 894, and Senate Bill 1294. You all can figure out how you're going to sit up there and who's going to speak first. Senators Trent, Carter, and Nicola. I thought they were here. I need my glasses back on. Getting old. Well, I was hoping Joe sits on Curtis's. I'm kidding. You can just figure it out, like whoever wants to present, and then I know you've got a committee, so, and I know Senator Nicola and Carter have a committee right after this, so after you present, don't need to stick around. I believe Senator Trent is going to be the handler of this combination. Has that been decided or no? Now, for everyone's knowledge, if you're first time here in the Judiciary Committee, bill sponsors will each get 3 minutes to present their bills. First two witnesses for and against, and we do alternate. We'll get 5 minutes to present their case. All other witnesses will get 3 minutes until the chair, the final 20 minutes of the hearing. It's chair's discretion to move it to a minute or 30 seconds. So with that, senators, take it away.
Thank you, Mr. Chairman. Members of the committee, Curtis Trent representing Senate District 20. This is the Truth in Sentencing Transparency legislation. My bill's Senate Bill 882. And this is, I think, a goal that has been discussed for some years now in the legislature, the desire to have a sentencing structure that is more transparent than what it currently is. It's more predictable for all parties involved, especially victims, and gives the public some sense of certainty that when a certain amount of time is given, that amount of time is going to be served, and give judges more clarity about how much time they're actually imposing on an individual when they sentence them. And so the way this legislation accomplishes that, to try to keep it within the time allotted, is by adding a fixed minimum parole eligibility requirement to statute rather than having those set by the parole board, requiring the court to factor in all applicable jail time credit at the time of sentencing based on certifications of time served provided by the jails, by preserving sentencing enhancements of dangerous felonies, various prior and persistent designations and dangerous offender designations, and life without parole sentences. And it does also include selected penalty enhancements for very select group of crimes. Section 566.030, rape in the first degree, 032, statutory rape and attempt to commit in the first degree, 060, sodomy in the first degree when the victim is under 12, 209, trafficking for the purpose of sexual exploitation, and added to the list of dangerous felonies, abuse through forced labor, trafficking for the purposes of slavery, sexual trafficking of a child, and failure to register as a sex offender for third violations. And if you look at the fiscal note on this, and I think the fiscal note is maybe not crafted to the version that we have here in the form of the substitute that I think is before the committee and has been distributed. There's a wide range of values that are kind of reflected there. I think this will probably be revenue neutral, at least in the short term, because the goal is not really particularly to change the amount of penalties that are available, or the range of penalties, but to provide that clarity and transparency. And then that will be a tool for the legislature going forward to adjust penalties to try to accomplish the purposes of the criminal code, which is to deter and prevent recidivism, deter and prevent crime in the first place, and to vindicate the both victims and the interests of society in order and justice. So that, Mr. Chairman, I will turn it over to my colleagues or be happy to answer any questions.
Are there any questions for Senator Trent on Senate Bill 882? Seeing none, Senator Carter.
No, I just want to echo the sentiments of our colleague, Senator Trent. I think I'm excited to see the penalty enhancements on a lot of these crimes that we've been discussing in the legislature for quite a few years, especially when it comes to trafficking and things like that of our children. Just really excited to see this piece of legislation get across the finish line. I think it does, it puts into actions the words that we say when we care about victims and the implications of holding people accountable and responsible for the crimes that they commit. So thank you for your time in hearing this piece of legislation.
Any questions for Senator Carter on Senate Bill 894? Hearing none. Senator Nicola.
There's not much I can add. As my colleagues had mentioned, Senator Trent did a great job explaining this piece of legislation. I would just add that we do need to have transparency and predictability, and I love the enhancements as well to some of these criminal offenses. And the families, the victims, they all deserve the transparency and this predictability, which I believe this bill will bring. I also want to bring to your attention, too, the effective date would not be until December 31st of 2027. So with that, I'd be happy to answer any questions as well.
That was the piece that you spread around the new part of the sub, correct? Subsection of this shall be applicable to offenses for which the offender was sentenced on or after August 28th, 2026, because I think it was 2023. I think the new language, okay. All right, any questions for Senator Nicola on Senate Bill 1294? Seeing none, last chance to question any of the witnesses before I release two of them. Hearing none. You two are free to go. First witness, I will say, on your witness forms, please clarify if you are for or against 882, 894, 1294, and you can simply just say all of the bills or single one of them out. So we will first have the first witness in support of either 882, 894, 1294, and you will have 5 minutes.
Thank you, Mr. Chairman, members of the committee. For the record, Trevor Foley, Director, Missouri Department of Corrections, here to testify in support for Senate Bills 882, 894, and 1294. The goal of transparency at the time of sentencing is a valuable one. I think it is important to note that this is likely not the end of the public policy debate, and I don't think anybody would present that this bill would be. This brings the transparency at the time of sentencing, provides more predictability to the system, and should allow a sentencing structure in the future that's easier for policymakers to adjust based on how that policy question goes forward over time. This is not an attempt to put more people in prison or fewer people in prison, just to inform those decisions and process. With that, I'd be happy to answer any questions.
Any questions for Mr. Foley? Hearing none. Thank you for your testimony today. We're going to switch to those opposed to Senate Bills 882, 894, or 1294. First witness in opposition. I was going to say, I think there's, didn't know if this was a consent bill or not. And just by show of hands, who all is in favor of these bills? Show of hands, who is all opposed to these bills? And informational purposes. Okay. Yep, you can sit up here. Introduce yourself to the committee, drop off your witness form, and proceed when ready.
Good morning. My name is Maureen Jai. That's Ndiaye. I'm with Forward.us, which is a national bipartisan political organization that works on criminal justice reforms across the country. And I'm testifying in opposition to 882, 894, and 1294. I will be very brief. I will say that these bills do not offer more certainty or transparency than the current law. As it stands, everyone has a minimum parole eligibility date, in which case they go up in front of the parole board, and it's up to the parole board's discretion whether or not that person will be released. These bills offer that same system. It will likely put more people in prison just because the fiscal analysis of these bills relies on averages, and averages mask the time that people are serving on both sides. For example, if the average time served for a crime is 30%, that could mean that everyone's serving 30% of the sentence, or it could mean half of the people are serving 15% and the other half are serving 45%. That's a very broad range and will definitely have an impact on the analyses of whether or not these bills will actually lead to more people being incarcerated for longer times, which lastly will cost more money to the tune of over $39,000 a year per person incarcerated. So I'll keep it at that. Thank you.
Thank you for your testimony. Is there any questions for the witness? Seeing none. Moving to informational purposes. First one for informational purposes, please come forward. Seeing none. Going back to, your witness form you can just leave up here. Going to in favor of 882, 894, and 1294, please come forward. You'll have 5 minutes.
Good morning, Chairman and members of the committee. My name is Locke Thompson. I'm the Cole County Prosecuting Attorney. I'm here today for the Missouri Association of Prosecuting Attorneys to voice our support for Senate Bills 882, 894, and 1294. I would disagree with the prior witness who stated that this would not lead to more transparency. I don't think it could be more clear that this absolutely would. Right now, when I'm trying to tell a victim how long their attacker is going to go away, unless there is a minimum set in the specific statute, it's really, really hard, if not impossible, for me to look that victim, sometimes a child, in the face and tell them how long that person's going to go away. And that's a really, really hard thing for those victims to accept and to kind of get through. So right now, I have no way of really knowing, unless I can wave a magic wand and try and figure it out. Under this, it would be at a set percentage. And so I could look that victim in the face and say, the judge just sentenced that person to 10 years, and at 70%, they're going away for at least the next 7 years. And so while it's not total truth in sentencing, this is an awful lot closer than anything we've ever had before. This is a huge benefit to victims around the state. And with that, I'm happy to answer any questions.
I know you usually have a lot of examples
Yes.
with real-life cases. Can you give an example of a real-life case without getting into names, but showing where a violent criminal was sentenced, a victim believed that person was going away, whether it was in your county or a different county, and they were shocked to learn that, hey, they're now on parole, they're back out on the streets. And are there any of these cases, if you can mention, where they're back on the streets and reoffending?
Yeah, pretty frequently you'll see people come out and then get caught right back in. And so I would say specifically on a lot of and I know that there will probably be witnesses against to talk about these percentages on the lower level felonies. But a lot of the folks coming out on lower level felonies are immediately coming right back into the county jail and picking up new offenses. And so it's a net wash, essentially, because resources are still being allocated to keep those folks incarcerated, whether it's prison or a county jail. Specific to violent offenses, yeah, I've had cases where the one I'm thinking of specifically was a young girl who had been abused by a boyfriend of, I believe, her older sister, and when time came for sentencing on that, and she said, oh, he's going to go away for this long, we had to say, well, maybe, but we can't be sure. And that's a difficult thing for a young child to hear.
I think it's difficult for any witness, especially someone who has been victimized by sexual acts and violent acts. Any questions for the witness? Senator May.
Good morning. How
Good
are
morning.
you?
I'm well. How are you?
I'm good. You said you're with?
The Prosecutors Association.
Okay, you're with the Prosecutors Association. So what I've seen is, an overpopulation in the criminal justice system of marginalized communities. Mm-hmm. So, and I know recidivism is a big thing, but I don't think we're addressing recidivism in these cases, or even trying to create some form of rehabilitation for those incarcerated. So when they come out, they revert back to the same thing, because we have no way of assimilating them into society. We've made it very difficult. So what's your perspective on that when we're looking at that data that we collect?
I think there are ways that this legislation can dovetail with good time credit legislation that would encourage individuals to participate in programs, things like that, while incarcerated, to better themselves for when they're released.
Yeah, but right now we're doing huge cuts to those programs. We've cut most of the programs that are going to help people in the prisons, and we're cutting the programs that help them when they get out. So I'm concerned, when we're looking at the metrics and these different marginalized communities, poor communities that individuals return back to. Yes, there are victims, and I have deep compassion for those victims. But if we don't change the mindset and mentality of those we incarcerate, we're going to continue to bear the financial burden of what we are creating.
Any further questions? Seeing none, thank you for your testimony. Next witness in opposition, please come forward. Make sure you have your witness form filled out clarifying Senate Bills 882, 894, and 1294. Which ones you're against?
Can you pass me a couple of those? I'm sorry.
And proceed when ready.
Good morning, Mr. Chair, members of the committee. My name is Mallory Rush, and I am the Executive Director at Empower Missouri, the state's oldest and largest anti-poverty advocacy organization. We are providing testimony today against all three of these bills, although our opposition is targeted at one particular piece of these bills. So these bills, one of the things that would be done with these bills is that it would do away with the program currently known as conditional release. And so at this time, barring any extenuating circumstances, this is the time that an incarcerated person must be released onto community supervision, which is where a lot of that sort of supervised rehabilitation that Senator May just mentioned happens. We believe that while the spirit of this legislation is to simplify Missouri's complex sentencing structure, we think that's really well intentioned. But doing away with conditional release without simultaneously reforming the state's parole process, we believe would have a lot of unintended consequences, leaving people incarcerated for much longer and straining the state's resources. Right now, folks on average spend about the final third of their sentence on community supervision under the conditional release policy. In FY25, according to the annual report put forth by the Department of Corrections, conditional releases made up of 13.5% of all releases from prison, or about 500 individuals. And only 5.5% of releases, or about 200 individuals, were folks who were discharged at the end of their full sentence. So sometimes they refer to this as being 12-12, where you do 100% of your sentence. Conditional release was created as a fail-safe to ensure that parole boards release people from prison for at least some period of time for that community supervision, so that they have time in a supportive environment to be able to reacclimate to living in the community. If the conditional release is no longer mandated, we don't think there's any reason to believe that everyone who is currently being held until their conditional release date would be paroled instead. Our parole process needs increased transparency and accountability so that those people who are denied parole know why they are being denied, and so that the public knows how the parole board is operating and if recommendations are being met. The proposed changes to the sentencing structure rely heavily on the parole board functioning fairly and effectively, and without any reforms being made to that process while implementing these bills, we think it's going to come at a very large cost to the state. And I would urge the committee to vote against these bills until this specific issue has been addressed. Thank you for your time.
Thank you for your testimony. Are there any questions? Seeing none. Going to informational purposes. Last call for informational purposes. Now moving back to those in favor. You'll have 3 minutes. Please come forward. Make sure you have your witness form clarifying which of the bills or all three of the bills you were in favor or against. Arnie, I do want to say something. You may have the biggest collection of American flag patriotic shirts I've ever seen. It's a different one every time, and I commend you on that. I don't know where, I'm going to have to talk to you offline to figure out where you get these, because every single time you come and testify, it's a brand new one.
Do you have any leads on some new American flair?
We can talk offline.
Okay, cool.
Begin when ready.
Thank you very much, Mr. Chairman, members of the committee. Good morning. My name is Arnie C. A.C. Dinoff, State Public Advocate. You know, I testified a few weeks ago back in the House on how the companion bills, House Bill 2637 and 2256. We need to do something in Missouri with truth in sentencing. Right now, when I go to the courthouse to monitor some cases, everybody shakes their head. The judges shake their head, the clerks shake their head, the prosecutors shake their head, the families and victims shake their head, because nobody knows exactly when that person is sentenced for a certain period of time to the state penitentiary of what their actual sentence is going to be. Judges shake their head because they sentence somebody to 15 years, and within 15 months or 3 years, they're back in front of the judge for either the same crime or more severe crimes that are putting the public safety in jeopardy. These bills need to build an even keel playing field for the victims, for the prosecutors, for the defense attorneys, for the public defenders, for everybody involved in the entire process. I'm a big believer that if you do a severe crime like what is mentioned in these three bills, SB 852, 894, and 1294, these are severe crimes. These are severe penalties. These are penalties that deal with rape, murder, robbery with the intent to produce harm. I could go on and on about the litany of charges that are in this bill. These are severe and should never be done to any other Missouri human being or any human being in our country or our world. We need to get some type of grasp on crime. I'm a big believer that if you do the crime and if you know better, you should serve 90% of your sentence, no ands, ifs, or buts, because you caused harm and grave concern to victims, to their families, to the mental anguish, to a ton of different things that just spiral into people's lives because they were a victim of crime. So we need to get a grasp of when either a jury finds somebody or convicts somebody, or a judge on a bench trial convicts somebody, that everybody, when they leave that courtroom or when the sentencing happens a month or 2 months after with the pre-sentencing investigation, that everybody in that courtroom is on the same field and knows exactly what that person is going to serve in the state penitentiary. I could go on. I'm passionate about this issue. It's just totally unfair of how the system is right now. These bills are great. I'd like to get them across the finish line and onto the governor's desk. Thank you, Mr. Chairman.
Any questions for Arnie? Senator Berger.
Good morning. I saw you last night at 7:30 walking your dog.
Yep.
And you had to drive back home.
Yep.
And you're back here by 8:30.
Yep.
And I see all those notes. When did you sleep?
I don't know. I got a few hours in there.
Well, I appreciate you always testifying and being involved. Thank you.
Thank you. I appreciate it.
Any more questions for Mr. Dienoff? Seeing none. Thank you for your time. Now moving back to opposition to 882, 894, or 1294. Again, reminder, this phase of the testimony, you will have 3 minutes.
Good morning. Thank you, Chair, members, and Senate. I am Sheena Rogers with Show Me Justice for All. I'm also a senior organizer for Missouri Justice Coalition. I just want to ask some direct questions first. How many people wanting these changes have actually walked inside a prison? Respectfully, have any of the prosecutors, former law enforcement attorneys ever picked up the phone and called probation and parole, someone who is sentenced, and asked, what is the minimum they will serve? What is the maximum? What is their good time date? What is their CR date? What is their max out date? Because they will tell you, they have an assessment that they already use for these offenders. It's called the Ohio assessment. When someone goes to prison, they receive what's called a face sheet. On that sheet are 4 dates. We know exactly what we are facing when we go to prison. Those making these decisions could know with a simple phone call to probation and parole. Let's talk about the narrative I keep hearing, that sheriffs, prosecutors are tired of arresting the same people over and over again. If you are arresting the same people over and over again, it's evident what we are doing is not working. Longer sentences are not a strategy, they are a reaction. But if you don't address addiction, trauma, poverty, lack of education, and lack of opportunity, you're not solving crime, you are recycling it. This will affect C, D, and E felonies. Why we are talking about more time instead of more treatment for these people. Help me understand how is spending 4 times as much money to warehouse someone fiscally a conservative choice. And let's be clear about violent offenses. Those required to serve 85% are actually serving 90%, if not 100% of their sentence. They're not even eligible until they do 85%. This bill will increase prison populations. That is not speculation, this is math. We already cannot staff the prisons. Even Director Trevor Foley admitted this in the budget hearing. Officers are exhausted, facilities are short-staffed, conditions are strained. So what's the plan? Build more prisons? Because that's where this bill will go. Judges already have discretion. They can actually sentence someone to a certain percentage. They can tailor sentences case by case. Why remove nuisance and replace it with blanket policy? To the prosecutors who are frustrated at this time, respectfully, you negotiate these plea bargains. You decide the charges, and you are part of the process. If the outcome isn't working, the answer isn't automatically more time. If we truly care about public safety, we invest in what works, not what sounds tough. Mass incarceration has already proven to be expensive and ineffective. So I stand here in strong opposition to this bill, and I ask you, not emotionally, not politically, but logically and physically, how does expanding incarceration solve a problem that incarceration has already not solved? Do not pass this bill this year. Study it, examine the staff crisis. You cannot keep doing the same thing to the same people at a higher cost and expect a different result. Thank you.
Any questions? Seeing none. Thank you for your testimony. Make sure you leave your witness form. Moving back to those in support of these 3 Senate bills, 882, 894, and 1294. Any more in support? Last call. All right, moving back to those opposed to 882, 894, and 1294. Begin when ready.
Good morning, Senator Schroer and members of the Judiciary Committee. My name is ML Smith. I am the founder and director of an organization called Missouri Justice Coalition, and I am here to strongly oppose 894 and 1294. Those 2 particular bills will require several more prisons to be built in the state. And we just don't have the capacity in order to do so, either staff or the monetary capacity to pay for them. But I do want to talk a little bit more about 882. There are some parts of 882 that I do agree with, and some parts I don't. I will say that we do need to restructure the sentencing of Missouri. It is very convoluted. It is very confusing to people who are in prison. We do, like Ms. Rogers said before, we do get face sheets and we do know what those numbers are, but the actual serving of time and things happen once the person is incarcerated that can possibly change those numbers. So a couple things that I have a few questions about, and I would like to talk to the committee about, and hope that you have questions about these things. One is there's some confusion within the bill. There is currently a statute, RSMO 558.026, and I wanted to get some understanding because it's talking about concurrent sentences, and the new law would say that people have to serve 50% of their sentence on each one. Well, currently we have an 85% law about dangerous felons. So this is in contradiction because will the person have to serve 50% on each charge that they're in prison or will they still have to serve the 85%? The new language in the bill is highly confusing concerning that particular statute. I also want to talk about removing the first time incarceration not being counted as a prior commitment. the new bill would take that away. So each time a person is in prison, it would count as a commitment on their subsequent sentencing. And I want to say about that particular thing, we have something called 120 shock. And I'm not quite sure if the committee understands it, but it's basically when a person goes to prison for 120 days to do a treatment and incarcerated treatment program when they have some type of substance abuse problem. So counting that time as a prison commitment would really impact a person's future. And also, if we were taking that away, not counting those 120 shock, if we're taking that away from not being counted as incarceration time, then I don't think treatment should be mandated in prison. I believe that treatment should be a community thing. So
while your time is expired, I'll give you a couple seconds to wrap up.
So those are a couple of the specific questions that I have about the bill. I do think, again, that our sentencing structure should be fixed. But like Mallory said, and like a few other people said, parole needs to be updated, and we really need to delve into this a little bit further, not just with the sentencing commission, but with community, right? And no one on the sentencing commission there are two positions that are supposed to be private citizens on the sentencing commission. Currently is Sheriff Cole, who is elected, he's not private, and a captain of the Jefferson City Police Department. Those are not private citizens. We need the public and the community on these commissions as well. So I want to end with that. Thank you.
Any questions for the witness? Seeing none. Thank you for your time. Any others in opposition to 882, 894, and 1294?
Good morning, Chair, committee members. Sage Quorum on behalf of the American Civil Liberties Union of Missouri, here in opposition to all three of these bills. We've heard already from other testifiers the grave concerns and questions with these bills. We echo them particularly on issues of conditional release, judicial discretion, and also concerns for services and programming for rehabilitation and reentry. And so we are here in opposition alongside with impacted people and their families.
Thank you for your testimony. Any questions for the witness? Hearing none.
Thank you. Would you give me one?
Any others in opposition to these three bills? Any more in opposition to 882, 894, and 1294? Seeing none. Last call for informational. Seeing none. Senator, any closing remarks?
No, I just thank the committee for its consideration. Thank you for the hearing, Mr. Chairman.
Thank you. That will conclude the public hearings on Senate Bills 882, 894, and 1294. With that, I'll be calling up Senator Brian Williams to begin us with Senate Bills 854 and my Senate Bill 1494 as I hand the gavel over to my best friend, Senator Carla May. We're not best friends anymore? Okay.
Oh, okay.
And for the record, this was this man's birthday yesterday, so please go easy on him. He just turned 32.
It's actually 31.
Oh, I'm sorry.
Good afternoon, Chairwoman and committee. Thank you for the opportunity for Senator Schroer and I to introduce Senate Bill 854 and Senate Bill 1494. This is an act to create provisions relating to expungement. As you all know, this has been an issue that I've worked on for quite a few years. I think it's created a pathway for us to be able to advance our workforce, but most importantly, put individuals on a pathway to become model citizens in our community. In essence, this act would help streamline the process of expungement in Missouri. As of 2024, over 500,000 Missourians are eligible for record sealing, yet only 1% actually receive expungement for their records. First and foremost, this act would mandate that as of August 28, 2029, 2029, all records and files eligible for expungement shall become closed records without the filing of a petition. Subject to certain requirements, it would also provide time limitations for when records will be closed and limitations on the number of offenses which may be expunged. This reduces the costly burden currently associated with record sealing, which would also help Missourians financially seek expungement that are not capable of doing that. Next, as of August of 2029, the Office of State Court Administrators would be mandated to identify and transfer monthly all clean slate eligible offenses records to the central repository and prosecuting agencies within 30 days of offenses becoming eligible for expungement. In closing with that, records of expungement would also be made available to judges in the circuit court and highway patrol. This act provides that the petitioner will be considered not to have been previously convicted except for purposes of the requirement to pay restitution. Lastly, this act also provides for the creation of the Missouri Expungement Fund. This would provide upgrades to systems and staffing and more effectively facilitate implementations of these provisions. Again, as I stated, colleagues, we have over 500,000 Missourians who are eligible for expungement, with thousands more living with non-violent records. Many of these people make up our communities, our friends, and family members. And for these people, record sealing and expungement would radically change their lives and result in an easier time finding employment, housing, and starting a family. So let's modernize the expungement system and lessen the financial barrier for those who need a clean slate. There will also be a Senate committee substitute at a later time to address some things that we needed to clean up. But ultimately, again, I think this is a great opportunity for our state, and most importantly, a great opportunity to put people on the pathway to be model citizens and, of course, enhance our workforce. Thank you very much, and with that, I'll hand it over to Senator Schroer.
Thank you, Senator. I want to thank Senator Williams for spearheading this for many years. I started with this bill back in the Missouri House and quickly found out that it was a bipartisan effort, and it's the same thing over here. Look, when you're looking at some of these expungements, we're not giving somebody a free pass that doesn't deserve it. They already are entitled to these expungements in law. And as a practicing attorney, when I did criminal defense, it was very difficult to navigate the expungement system. You almost had to find an expert who dealt with that to figure out if you're meeting all of the different things that you have to jump through, all the hoops that you have to jump through to get this person the expungement that they're already entitled to. And I like what Senator Williams said about modernizing the system. This is taking our archaic criminal justice system, which is, I liken it to Blockbuster Video. We're all old enough here to remember Blockbuster Video, and we're moving it to Netflix. We're moving it to the streaming services. These people are already entitled to it. I think you're going to hear today that most of the people that are even opposed to the bill aren't opposed to the concept of modernizing this. They're just worried about the cost. And Senator Williams has done a great job over the past several years that I've been in the Senate and even in the House of trying to get all the people to the table to figure out how we can use the existing resources that we have, the databases that we currently have. And now we're talking about maybe implementing with AI, trying to figure out who is available and who's not, to filter out those cases as well. So while we're talking about cutting spending at the Republican Party, yes, we're keeping that in mind. We're keeping in mind that we want to cut spending, unnecessary spending, but let's weigh the benefits that passing this bill will have not only on our economy, but the public safety in our state as well. As these people are given a clean slate and get this stuff off the record, they can now get grants to go to school, scholarships to go back to school, they can get jobs, they can get housing, and that absolutely will impact the recidivism rates and be a positive impact on the economy as they start producing for the economy rather than going back into the system where taxpayers are paying for their housing as they're back in jail. So with that, I will open it up to any questions, but I will have to go present another bill. Chairwoman, I think we have one more bill after this. If I don't make it back, I'm confident in you.
I appreciate that. Thank you both for the bill. How many people are here to testify in favor? Ooh-wee. How many here are to testify in opposition? Okay. So we're going to bring our first witness in favor.
Good morning again. For the record, Mallory Rush, Executive Director, Empower Missouri. I'm thrilled to be here today to offer testimony in support of Senate Bills 854 and SB 1494. Our nation's criminal justice system was conceived and implemented long before the internet became an integral component of our society. The justice system was designed to both punish and rehabilitate people who break the law, serving as a deterrent for illegal activities and offering corrective supports to those who have broken the law out of desperation due to mental illness or addiction, or as youthful indiscretions. Individuals are tried by a jury of their peers, and if they are found guilty, they are sentenced to a punishment that is commensurate with the level of harm caused to the community. The system was not designed to punish people for the rest of their lives. However, with the advent of the internet and online repositories for criminal records, this is the reality in which we currently live. Many individuals with old criminal records report years or even decades of struggling to secure employment and housing due to the high prevalence of background checks conducted by employers and landlords. Nearly 9 out of 10 employers use background checks in hiring, and an estimated 4 in 5 landlords use background checks on prospective tenants. In turn, an applicant with a criminal record is 50% less to get a callback or job offer than an identical applicant without a record. And between 60 and 75% of formerly incarcerated individuals remain unemployed 1 year after their release. And we see that previously incarcerated folks are 10 times more likely than the general public to end up homelessness. With 1.8 million adults with criminal records in Missouri, this has resulted in staggering poverty, with ripple effects extending beyond the individual and impacting families, communities, and our society as a whole. The American Conservative Union's Nolan Center for Justice asserts that the harm done by a sentence should never be greater than the harm caused by a crime. But records for offenses like drug possession, writing a bad check, or petty theft can amount to what feels like a life sentence of being denied jobs, apartments, access to loans, and other collateral consequences for past mistakes. Clean slate is important because it ensures that punishments fit the crime and have a clear end date rather than lingering for a lifetime. When we continue to punish people for years or even decades for previous mistakes, we drastically hinder people's ability to provide for themselves, forcing them onto social safety net programs or back into criminal actions that send them back to prison, both of which come to at a very high cost to both taxpayers and society as a whole. Unfortunately, our current system of expungement just isn't working. As you heard Senator Williams say earlier, less than 1% of people who are eligible for expungements are able to get them under the current petition-based system, which is costly and complicated. It's important to automate the process to make it accessible to all Missourians, whether or not they have the knowledge, time, and resources to navigate a complicated, costly system over months or even years. However, it is important to remember that expungement would remain unavailable to people who have committed violent or sexual offenses, and individuals do have to meet a number of standards to qualify for the automated process. I want to just highlight that not only is this a bipartisan effort in the Senate, but there is a bipartisan effort happening on this bill in the House as well. Representatives Bishop Davidson and Marlene Terry combined their bills in committee, and they were voted unanimously out of their originating House committee yesterday. So we are very hopeful that the Senate will follow suit. I know that Senator Williams and Senator Schroer are willing to look at the amendments that were made to the bill on the House side. We did some really extensive work with the Prosecutors Association, with Highway Patrol, and with the courts to ensure that the fiscal note for this bill could come down substantially. And with that, I will take any questions.
Okay, thank you. Did anybody have any questions? Okay,
Actually, quick question for the Senator. Senator, same thing as you did last year?
Same thing we did last year. We will have a Senate committee substitute which will address fiscal concerns and also make it clear on what population would benefit from the expungement process.
Beautiful. Love it. Thank you.
Thank you. All right, thank you. Next, in opposition.
Madam Chair, members of the committee, Eric Jennings, Supreme Court Government Relations Counsel on behalf of the Judicial Conference. And Chair Schroer was absolutely correct, and I'll preface this the same way that I did my testimony last year. Our opposition on both bills does not have any bearing on the policy of expungement. That is a determination by the legislature who receives it, how long and in what manner. Our concerns were solely centered around the mechanism that's laid out and the bill is introduced, and our opposition is only to the bill as drafted. And as the prior witness had testified, we've had several productive conversations, both with the Senate sponsors, but also with Representative Davidson on the House side, in terms of addressing what I have outlined before is the misalignment of function and information being possessed and who's being asked to do what in what order and along what timeline. And House Bill 2747, the House Committee substitute that was voted out yesterday, has a much better alignment on that in terms of who is being asked to perform what functions in what order, and who has possession of what data that they need to perform those functions. So that's pretty much the sum and substance. I'd be glad to answer any questions if you have them.
So you're saying that you're not objecting to the premise, you're objecting to how the process works in getting it done.
Correct. It did not make much sense. I've mentioned before, the judiciary and the show-me courts in our court automation system, the basic building block for that is the case file, the case record, not the individual. And because of the way that that's been constructed and work that's been done on that, it is not necessarily a system that we can go in, pull a name, and pull up every case associated with an individual person, although we are in the process of work with the Highway Patrol to address that. That's not the same as, for instance, the Highway Patrol being asked to do a criminal background check, where the basic building block for that is the person. There's a specific number associated with those individuals, and they can pull up their criminal records associated with that individual. So House Bill 2747 shifted that initial function of identifying eligible offenses to the Highway Patrol rather than OSCA. Because asking OSCA to do a criminal background check is going to require us to build a whole new system to do it, and to make sure that we have the data that's necessary to do it, which we didn't. So we have shifted that, and then that information gets passed along to OSCA. OSCA communicates through, at least in the House Committee sub, through its regular channels with the circuit courts. They process those as they would now with an order of expungement, and then information is sent back to the patrol. And also communicated out to law enforcement by the patrol, which has existing communication channels that OSCA doesn't have to every law enforcement agency in the state. So it was a realignment, handing the right people the right duties in order to get maximum efficiency out of it, which should affect the fiscal note on it.
Okay, thank you. Any questions? All right, thank you.
Thank you.
Thank you, sir. Next in favor.
Hello, members of the committee. My name is Patrick Benson. I want to first off thank you for hearing my testimony today. I am a social worker with Criminal Justice Ministries. We're a reentry organization in St. Louis that takes people that are justice involved and does reentry. Our primary purpose is to housing first, and then get them aligned up with employment and get them reentered into society after this involvement. The number one factor, I work with, we have 3 grants at my organization. We have a civilian men, civilian women, and I'm with the veterans program. The number one factor across all 3 of our grants, whether or not we can successfully transition a person from reentry into sustained living, is whether or not we can get them a good job, and whether or not we can sign them a lease in an independent housing situation. That's the number one factor. If we can do those 2 things, we've dropped our recidivism rate from the statewide level of 44% to we're in the low teens in criminal justice ministry. Now, there's many veterans and civilian men and women we're the minority of people that are justified because they come through our program, but we are extremely successful at what we do. Also, the number one factor that determines whether or not that they don't successfully reenter is whether or not we can get them that job and that sign a lease into a place. So having these records sealed would do vast benefits to my clients and really to society as a whole as they re-enter society and get back paying jobs and paying taxes in the system. I testify in support of this bill professionally, but I also testify in support of this bill personally. I'm also a Justice Involved veteran. In 1994, after getting out of the Marine Corps, I entered the fire service as a firefighter EMT first, then a firefighter paramedic. And in 2002, I ran a really high amount of extremely traumatic calls, but in 2003, one in particular, I ran a 2-year-old girl when my daughter was 2. That was a pretty tragic incident. It wasn't long after that where I developed into substance disorder, and I was in and out of recovery for the next 16 years. So finally, in 2017, I was in a single car accident while under the influence. I hit a tree doing 90 miles per hour, and I woke up 3 months later in a skilled nurse facility. Ended up having my leg amputated, and that wasn't enough to get me quit. And then in 2019, I was arrested on a low-level drug offense. I was given the choice of doing Veterans Treatment Court, which I did, and during the course of that Veterans Treatment Court, I was diagnosed with PTSD. Those years of in recovery and out of recovery were pretty much futile until I started addressing that PTSD. Since then, I'm now facing coming up on 7 years in recovery, and since I've been in Veterans Treatment Court, I've graduated with my bachelor's in social work, and I'm in grad school now with a goal of working with first responders dealing with trauma. I tell this story, in 2003, I got an award for going into a house that was on fire with another firefighter. It was an occupied house. We pulled an elderly woman out. She was in cardiac and respiratory arrest. We started CPR on her, and we got her back, transported her to the hospital, and we got an award for heroism for that. Now, I didn't say that not to brag, but that was one of the greater moments in my life. Today, when I fill out a job application or apply for a lease on an apartment or anything like that, they don't ask me about the one greatest moment of my life. They do ask me about the one lowest moment of my life. And I'm not going to rate me for the rest of my life based on one greatest thing I've done. I don't think it's fair to rate me for the rest of my life on the one worst moment of my life. I worked extremely hard to overcome those barriers to reentry and to get my life back together and making something of my life. And all of the clients that I work with are usually doing the same thing. And most of these crimes is a pretty tragic human story. And these people that I work with and others that aren't fortunate enough to work with us are really trying to overcome the barriers that these criminal records present. So I fully support Senate Bill 854 and 1494 for both professional and personal reasons. I'm willing to take any questions.
Any questions? Thank you.
All right, thank you.
Make sure everyone fills out a witness form, please. Next in opposition.
Good morning, Madam Chairwoman, or Vice Chairwoman, members of the committee. My name is Arnie C., AC Dinoff, State Public Advocate. I have to oppose SB 854 and SB 1494. Expungement. People can overcome what they've decided to make wrong decisions or bad errors in their life. They have to understand that they took effect and they affected other Missourians with certain crimes. Now I feel that felonies should never be removed from anybody's record. As a matter of fact, there's a person who's serving the General Assembly who is a convicted felon. And that person, for some reason, escapes the law that says that if you're a convicted felon, you can't be an elected official, and I'm not exactly sure how that person is in the General Assembly. It doesn't mean that if you do a crime, a misdemeanor or a felony, and it's on your record, it doesn't mean that you can't change your life around and overcome that. One needs to be responsible and accountable for their illegal and unlawful actions. Hopefully most of us, our parents or loved ones in our life, have instilled us with morals, ethics, and not to break the law. Sometimes we become complacent, and sometimes it's okay. It feels like it's okay in society that we allow people to break the law, and it's okay. And then all of a sudden, give them a free pass or another chance. I'm about second chances. When it comes to DUI, I think that if you get one DUI and you don't learn your lesson, I don't think you should ever drive again, because you could turn somebody's life upside down and hurt somebody for the rest of their life in an instant split 1/4 of a second. Some courthouses have become a revolving door. It's the same crime, the same characters over and over and over. Law enforcement in my community, they see the same 10% of the criminals over and over and over. Now, I am about second chances, and if the bill stated that if the person would not be a repeat offender for misdemeanors only after 15 years, I would be amicable to taking that off their record and giving them a second chance. But when it comes to felonies, it should never come off of one's record. They should have to be remorseful and deal with that for the rest of their life, because they made that decision when they committed that crime and turned that victim of the crime, their life upside down, or their families upside down. And that, the victims are forgotten in a lot of these crimes. It's not about entitlement in life. It's about doing the right thing and being a good human being and a good Missourian. I believe in our jury trial system and our bench trial system at the circuit court level. And guess what? If the defendant feels that there's an error and that they're wrongly convicted, we have an appeal process to the Missouri Court of Appeals, to the Missouri Supreme Court, and even to the United States Supreme Court if you feel that our Supreme Court justices erred. Now, when it comes to the fiscal note, I want to remind each senator, we need to cut $2 billion from our fiscal year budget by 2028, or we're going to be in deficit spending. We need to cut $1 billion in this fiscal year coming up for 27 and $1 billion from 28. The fiscal note for 2027 is $30 million and more than 344 full-time new employees. In 2028, the cost goes up to $50 million on our budget, with more than 487 full-time employees that will need to be hired to take on this task. In 2029 and succeeding years, until it's fully implemented, it will have an effect of $50 million and more than 487 full-time employees. The bottom line, senators, is hopefully your parents and your family taught you morals and ethics when you were a toddler and a youngster, and there should be no free passes in life. The Missourians should not have made the bad decision to do the crime in the first place. So for those reasons, because the bill doesn't say that if you have not reoffended in 15 years and have some type of constraints and some type of boundaries of responsibility and accountability, I oppose SB 854 and SB 1494. Thank you, Madam Vice Chairwoman.
Thank you. Just in time. Anybody have any questions? All right. Thank you.
Thank you. Also, just for the record, so we don't get lost in translation, anyone that is eligible to receive an expungement under this bill are already eligible in the state of Missouri.
Yes.
So there's not going to be a new exception or new crime. And also, if someone was in a vehicular accident that involved a death, that would be considered a violent offense. So this is only eligible to those that have been convicted or arrested for nonviolent offenses.
Yes. Okay, thank you. Do we have next in favor? How many more people you got in favor? So now we're going to have to go to 3 minutes per testimony. We have another bill to hear, and we got to be out of this room. So it's another committee. It's the truth. Yeah. Go ahead. Begin when you're ready. We need you to speak in the microphone.
Oh, I'm so sorry.
That's my fault.
That's okay. Good morning, and thank you to the chair and to the members of the committee. My name is Jackie Hebe, and I'm the proud owner of 2 storefronts in St. Charles, Sugarbot Sweet Shop and Sugarbot Creamery. I have previously testified twice in support of this legislation in the House committee as a business owner and a lifelong Missourian. Today I am here once again in continued support of Clean Slate Missouri, this time under Senate Bill 854 and 1494. I started Sugarbot in 2012 with the desire to control the products I made and to enable myself to do business in a way that aligned with my personal values. In 14 years of business ownership, I've grown and supported the community through acquisition of 2 other small businesses and have purchased, fully rehabbed, and continued to maintain both buildings, as well as my home. In 2024, Sugarbot was honored to have received the Grow St. Charles Award, which is presented to a business that has made meaningful contributions to the city based on environmental, community impact, innovation, and employment programs. Last year, Sugarbot was selected to participate in the Schnucks Springboard, Goldman Sachs 10,000 Small Businesses, and the UMSL Anchor Accelerator cohorts. And I am proud to report that just last week, Sugarbot was awarded a Chase and Independent Restaurant Coalition Innovator Award. I am deeply proud of the work that I have done and the work that I will continue to do within my business and greater community. I say all of this to share that Sugarbot exists to be a place for families, for celebrations, and for sharing. Above all, we believe in empowering folks to do better, not just for the ones that they love, but also for themselves. And we have seen positive impact that mindset has on our business and our community. Everyone knows someone that has made a mistake that they regret and have learned for it, and humans deserve second chances. I don't say that we believe and support these things in a hypothetical sense. We could not have accomplished all that we have without a strong, dedicated, and devoted team. And our team at Sugarbot 100% has a systemic barrier to employment. We actively employ folks with felony convictions, as well as those who have grown up in the prison pipelines that continue to exist in Missouri and beyond. In my prior testimony, I shared details of our first previously incarcerated employee who was released in 2020 after serving 36 years in prison. I am happy to share that he is still with us today and continues to be an asset to our business. We continue to offer positions to those rebuilding their lives from much less severe crimes, including those that would be impacted by the passage of Clean Slate. On several occasions, I've witnessed folks who are forced to decline our offers due to housing or transportation limitations, even though many live within a short 15-minute drive of my business.
Thank you.
Indeed, I submitted my written testimony online, so you can read the rest as well, but I want to honor the time, and I thank you.
Absolutely, thank you.
Thank you for what you do.
Anybody have any questions?
Thanks for your time.
Okay, thank you. Is there any other in opposition? Any opposition? Going once, going twice. No other opposition for the bill? Great. Anybody for informational purposes only? Informational purposes only. All right.
Good morning. My name is Alex Tuttle. Good morning, Senator. On behalf of the Missouri Chamber, we'd like to go on record as support of the bill. This has been a long-time workforce priority of ours. We want to thank Senator Schroer and Senator Williams for continuing to push this effort.
Thank you. Any questions? Thank you. Quick testimony. Any more in support? Support.
Okay, good morning again, Chairwoman. I am, again, M.L. Smith with Missouri Justice Coalition. I wanted to just say a few quick words about these bills. I do want to thank Senator Williams and Schroer. I am a person who is formerly incarcerated and who is impacted by a continuous othering of myself. I call it the scarlet letter F instead of A. And for years, I have been denied employment. Now I run my own organization, so I don't deal with that, but I do deal with housing discrimination. And I had one elected official tell me I should just keep applying for housing, and I explained to him I don't have $100 to keep paying application fees and getting denied because I have a criminal history. I exited Missouri Department of Corrections in 2015, and I'll be 50 years old this year, and still today I cannot rent my own home. Right. I'm looking right now trying to figure out how to buy a home because I need to move from living with a relative. But again, I don't have money to keep paying for landlords to deny me. And this is such a horrible situation. So I would encourage you all to support these clean slate initiatives. Again, we are eligible. It is a cost, barrier to people being able to do this. Also, you have to currently, in the way it's set up, you have to travel to the county that you were convicted in, and it's a court process to be expunged. And a lot of us don't have the capacity to travel, don't have the money to do so, or don't have those court fees. So there are ways to do this automatically. Other states have implemented it. There are entities that help with the automation process, including Code for America. So we encourage the committee to support it, and after it's passed, do the work to implement it with people across the state and across the country. So I just want to leave you with that, and again, thank you very much.
Thank you. Any questions? All right. Next in support.
Good morning.
Good morning.
What do I say, Madam Chairman? I just want to make sure I'm politically correct. My name is Pastor Richard Jackson. I am the founder of Manasseh Ministry. We help families who have loved ones incarcerated. Excuse my voice. But I'm here to support bill number 894 as well as 1494. In this bill, or in conversations or in witnessing, I noticed that there is little discussion about the pain that women have to deal with when the man cannot get a job or the woman cannot get a job. And having experienced that backdraft of having to deal with that and the pain of that and how embarrassing it is to keep on carrying the load because the individual is doing the best that they can to get employed, but they can't. That's hard and that's challenging. As a returning citizen, I never had to face that because I was married. My wife and I just maybe her, but I never had to face that. I never had to face when I bought property. I never had to face those challenges, but I also didn't have to face dealing with my son being killed during the Mike Brown uprising, but I still was there protesting because it was injustice, it wasn't right. So I'm here to stand for those individuals who can't get jobs, who cannot move where they want to move, who cannot get the education that they want. And in closing, when Martin Luther King went to Washington, they titled the message, "I Had a Dream," but that was never the message. He went there to talk about a check and fair play. And so how I coordinate this? I'm gonna tell you how I do it. Mahalia Jackson was on the side saying, "I have a dream," and so for so many years they've used that as "I have a dream" to push the agenda of what the late Dr. Martin Luther King was about, and that's good. We need to be able to understand that you can't keep on thinking that denying people the opportunity to get what they need is right simply because you feel that it's unfair for them because they've done a crime and they should always be punished. That's not even what God talks about it in this building. I see so many scriptures. I'm just wondering, is that architectural designing or did we really mean that? And with that, I close.
Thank you. Any questions?
Thank you.
Thank you so much. The next in favor? How many more in favor we got? Okay.
Good morning, Chairwoman and committee. Thank you for the opportunity. My name is Ryan Barker. I'm the Chief Policy and Program Officer at St. Louis Integrated Health Network. Just to emphasize what has been said, agree with Mallory, the businesswoman. IHN also runs a reentry program in St. Louis City and County, folks coming out of jail or prison. The biggest barrier for our clients is both housing and employment, and a lot of the challenges come from having a record. And while these bills will not immediately help our clients because we work with folks coming out day one, in the long run, it will, and the reasons for why we support have been stated. I will just quickly share a quick story. In our program, we prefer to use community health workers to work with these clients, especially those that have lived experience. That means either our staff have worked in the criminal justice system for a significant amount of time or have been in jail or prison themselves. I have now helped 2 of our staff try to get their records expunged. I think I'm a fairly well-educated person, and it was incredibly difficult to navigate the process and fill out the paperwork. And so we wholeheartedly support both of these bills. Thank you.
Thank you, sir. Good to see you. Thank you so much. Any questions? Senator Berger, you good? Okay. Next in favor?
Good morning again.
Good morning.
Thank you. Just state for the record, I'm Sheena Rogers with Show Me Justice for All and senior organizer with Missouri Justice Coalition, and I just want to go on record to support this. As a formerly incarcerated woman myself, I also run a transitional house for women, and the barriers that we keep coming across is their possessions. These are not felonies that my ladies have. These are, that it has gotten to a felony with having possessions. But I have 7 women in my house that were facing homelessness because they were formerly incarcerated and cannot find a house. So I would just like to go on record that this could help change people's lives. I worked in a law office. They would, as a paralegal, it was very difficult to even navigate the expungements. Not only that, lawyers were charging way too much to help people do these expungements. So this takes that barrier out for people to get a new start at life and help women like I am helping in reentry get a fresh start. Thank you.
Thank you.
Thank you.
Any questions? Next in favor?
Thank you, Chairwoman and Committee. Kurt Wickmer with the Missouri Catholic Conference, going on record in support. A lot of other people have brought this up today, so I will do the same. Second chances. The Church believes in second chances, and we believe this bill does a good job of streamlining the process for a second chance to those who have shown responsibility and accountability with their behavior after release. So I'd like to thank the bill sponsor for bringing this, and I thank you for your time.
Thank you. Any questions? Next in favor? All right. Any more in favor? And make sure you fill out a witness form. Everybody has to fill out a witness form.
Good morning, Chair, committee members. Sage Quorum on behalf of the American Civil Liberties Union of Missouri, going on record in support of both of these bills. Again, aim to update and strengthen the process for record expungement to ensure that every eligible Missourian is able to receive their second chance.
Okay, thank you. Any questions? Thank you. Next in favor?
Madam Chair, members of the committee, Brian Bernskater here on behalf of the Missouri Association of Criminal Defense Lawyers, just to go on record in support. This is a very big issue. We get clients calling every day needing help with this, and so having this opportunity we think is very important.
Thank you.
Thank you.
Any questions? Next in favor? Any informational purpose? Any opposition? All right, that concludes the hearing on Senate Bills 854 and 1494. Next, we'll have the hearing on Senate Bill 928. Tucker just left, didn't he? Okay, yeah. Okay. You can begin when you're ready, Senator.
Madam Chair, distinguished members of the committee. For the record, I'm Senator Patty Lewis, representing Senate District 7 in Jackson County. Thank you for the opportunity to present Senate Bill 928, which addresses domestic violence. I did work with the chair he gave me the opportunity to present the sub, which we've sent to you, and I'm going to go through what the difference is from the original bill and the sub. But before that, I just want to talk about the history of this bill. Last year in committee, I heard that Missouri is ranked 3rd in the country for the number of people who have experienced domestic violence. 3rd in the country. I also heard that the leading cause of death for pregnant women in the state of Missouri is domestic violence. So during the interim, I think we've done a lot of work to address domestic violence, but I want to do more. And during the interim, my office and I worked with various stakeholders. First of all, I had some urban leader fellowships assigned to my office, and I tasked them with finding more information on what we can do about domestic violence. We met with various stakeholders in my community, including Kansas City Police Department, Chief Graves, Captain Hewitt, and the Special Victims Unit. Special Victims Unit from the Jackson County Prosecuting Attorney's Office, advocacy groups like the Missouri Coalition Against Domestic and Sexual Violence, and Synergy Services, just to name a few. And our common goal is to help survivors, law enforcement, and prosecutors better protect survivors and bring justice. I heard something from KCPD when I met with them that domestic violence perpetrators are dangerous to everyone, including law enforcement. So what this bill does, it streamlines the order of protection and removes the burden off the survivor. It provides updates on statute and definitions of assault and domestic violence. The prosecutors wanted this information to better protect victims. It also adds technology language to stalking and harassment. I also wanted to include recommendations from the Stop Cyber Stalking and Harassment Task Force. They released an annual report this past December to the General Assembly, and I want to acknowledge Senator McCreary and Senator Schnelting, who serve on this task force, and worked very closely with Senator McCreary and her office to include the recommendations and include this in this bill, which is adding cyber stalking to orders of protection. It allows the Attorney General and prosecuting attorneys concurrent jurisdiction. It updates offenses on harassment and creates new offenses for unlawful tracking of a motor vehicle, cyber stalking, cyber harassment, disclosure of intimate digital depiction, and online exploitation. What it doesn't include from the original bill is the increase hold from 24 hours to 48 hours. I received some pushback on that provision. I wanted this bill to be non-controversial. I think that will be for a different conversation to include all parties to work something out. So we've got plenty of witnesses behind me, including advocates, law enforcement, Jackson County Prosecuting Attorney's Office, but I'm happy to answer any questions.
Awesome. Any questions for the senator? Okay, thank you. First witness in support.
Good morning. My name is Jessica Hill, and I am the Chief Public Affairs Officer for the Missouri Coalition Against Domestic and Sexual Violence. We thank Senator Lewis for contacting us and working with us on this bill. On behalf of MOCADSV and its almost 100 member agencies who provide services to the state's victims of domestic and sexual violence, we thank you for the opportunity to provide brief testimony regarding Senate Bill 928, sponsored by Senator Lewis. This bill strengthens protections for victims of domestic violence, assault, and stalking by closing gaps in current law and ensuring that law enforcement and the courts have clearer, more effective tools to intervene. By redefining levels of harm, such as great bodily harm, substantial bodily harm, and bodily harm, the legislation creates clearer standards that better reflect the real impact of violent conduct and support consistent prosecution of assault and domestic violence offenses. The updated stalking provisions modernize the law to address patterns of harassment, intimidation, and technological abuse, as Senator Lewis mentioned, focusing on the reasonable fear experienced by victims and expanding protection to family members, dating partners, and property. Finally, establishing the offense of violating a no-contact order reinforces the authority of the courts and ensures meaningful consequences for those who disregard protective conditions. Together, these reforms prioritize victim safety, improve accountability for offenders, and modernize the criminal code to address the realities of domestic and sexual violence in our state. We would also like to mention that extending the warrantless hold period from 24 to 48 hours in domestic violence cases would provide critical time to assess risks, secure charges, and protect victims during the most volatile period following an arrest. We hope that this language will be included in a future bill. Thank you for your consideration of this important legislation.
Thank you. Any questions? Thank you for your testimony.
Thank you.
Those in opposition? Any opposition? Great. Next in favor. And don't forget to fill out a witness form, please.
I have it with me. All right, how are you? It's good to see you. Good morning, Madam Chair and members of the committee. My name is Dr. Sarah Brammer. I'm with Synergy Services in Kansas City, Missouri, and I'm the Vice President of Domestic Violence Services. I am here with my esteemed colleagues and partners from the Jackson County Prosecutor's Office, Rosebrook Center, and Hope House. They are behind me. Thank you for the opportunity to speak today regarding Senate Bill 928 and Missouri's continued efforts to strengthen the response in domestic violence. Domestic violence is not a single incident. It's a pattern of coercive control that escalates and becomes more lethal with time. The most dangerous periods for a survivor are when law enforcement becomes involved, when survivors attempt to leave, and during the early stages of court proceedings. In Kansas City, the urgency is clear. Kansas City police respond to about 5,000 domestic violence calls annually. That's more than a dozen a day. Domestic violence-related homicides have risen sharply in the Kansas City area over the last few years, with 2025 representing the most lethal year on record. By the mid-year point in 2025, we had as many homicides in the Kansas City area due to domestic violence than the previous year in total, a stark reality to the problem in the Kansas City area. Domestic violence continues to be a serious driver of violent crimes in the region, affecting intimate partners, children, and extended family, and responding officers. Statewide, Missouri consistently ranks among the states where women are more likely to be killed by intimate partner violence. This is a sobering reality to the issues in our state. Senate Bill 928 represents an important step towards strengthening Missouri's response by improving accountability, expanding enforcement, and supporting coordinated interventions that protect victims and reduce repeat violence by holding offenders accountable. Research and frontline experience consistently show survivors are in the greatest danger when attempting to leave or when they seek protection. Prior threats, strangulation, access to firearms, and stalking are consistent lethal predictors. This was undeniably supported by the fatality review that happened in the Jackson County area this year. What we know by that is stalking and firearm access increase the risk to domestic violence survivors. Offenders who are not held accountable will be more violent in the future. We need bills that strengthen accountability and hold offenders accountable. Strengthening in Missouri's response involves consistent enforcement and accountability measures, tools that support law enforcement and prosecution of high-risk cases, court responses that reflect serious and lethal risks. Those particularly include when offender has access to a firearm, when they use strangulation or when stalking is involved. Coordinated connections to advocacy, shelter, safety planning are important and should be supported. Domestic violence homicides are preventable. Here's the thing, we can stop them all. Each case represents an example of where we failed a survivor and have an opportunity to do better in the future. Senate Bill 928 moves Missouri forward to continued safety-focused survivor protections. It offers offender accountability and community safety. Thank you for your commitment to protecting Missouri families and supporting survivors of domestic violence. Do you have any questions?
Thank you. Are there any questions for this witness? Thank you.
Good luck.
Don't forget to leave your witness form. Next in favor. Oh, okay. Okay. And so the remember, we're only doing 3 minutes. We have to get out of here.
Thank you.
Thank you.
Thank you for having me here today. My name is Danny Sadek-Sad, and I am the trial team leader for the Special Victims Unit in the Jackson County Prosecutor's Office. I have specialized in domestic violence prosecution for almost 10 years, including domestic violence fatalities. And like most folks who are drawn to this work, I have personal experience with family violence. And I'm grateful for the committee's attention to this issue, because it's not just a criminal justice issue, it's a public health issue that affects families, social circles, and the entire community. In regards to the level of injuries, I am very pleased to see cleaner and clearer language to differentiate between levels of assault. Knowingly causing physical injury to a DV victim is a Class D felony, which is punishable by 1 day in jail to up to 7 years in prison, while knowingly causing serious physical injury to the same victim is punishable by 5 to 15 years. That's a significant difference in severity. But the definitions of physical injury and serious physical injury are somewhat unwieldy, and that can result in disparate charging and sentencing, even in the same office, depending on the prosecutor or their interpretations of these injuries. For example, a through-and-through gunshot wound that does not impact bodily functioning for a protracted period of time may not be considered a serious physical injury, which does not make sense to most folks that you would ask on the street. The same for a savage beating. If you repeatedly punch somebody in the face, even if you cause fractures in the face, under current definitions, that may not qualify as our physical injury definition. That would render such a violent assault punishable by 1 day to 4 years and no more. Now, for a confession, while I myself am the one that suggested, I believe, to Senator Lewis, that I prefer Minnesota's 3 levels of bodily harm, and I think that was used as a template, I do have some concerns about language, and I've outlined those in my written testimony. But I do think that Senate Bill 928, specifically outlining fractures, is extremely helpful in maintaining consistent charging practices in sentencing outcomes across units and offices in Missouri, as that's a very common injury that we see. I'm also very pleased with the amendment to the stalking statute, which is an issue that we identified in the Jackson County Fatality Review. And better corresponds with our classic stalking scenario, in which a stalker does not intend for his victim to be disturbed or to even be aware of the stalking. Finally, that proposed 575, 275, and Senate Bill 928 is a statute that I have longed for Missouri to adopt since I arrived here from working in Kansas. Our friends in Kansas have long made it a crime for a defendant to violate a no-contact order issued by a judge in a criminal case as a condition of bond or probation, just as it is a crime to violate a civil order of protection. Here in Missouri, we have lacked such a statute. A court can order no contact with the victim in a criminal matter, but if the defendant violates that order, the prosecutor's only remedy is to file a motion to revoke bond and then ask the victim to appear and testify at a bond hearing, which increases the burden that we place on victims, and it's the same for the civil order. So I am grateful to see some teeth being given to these criminal no contact orders, and thank you for your time.
Thank you. Any questions for this witness? Okay. Please remember to leave your witness form. Thank you so much. Next in favor? How many more in favor we got? Okay.
Good morning.
I work with Maddie Road Center. Our agency and organization has been around for over 130 years. Oh, I'm so sorry. This is my first time testifying. My name is Monica Sierra Mayberry, and I represent myself as an advocate, a therapist, and now I oversee the program that has been in existence for over 20 years. In the time that I've been a therapist, I can just share with you so many stories of individuals that have come to me just sharing the impact that stalking has had on their lives and tech abuse. I'm not much of a tech myself, but I've learned that through their stories, they have found devices in their cars, on their phones, on their laptops, and it is so scary. It has taken many of our survivors over 20 times to just get the nerve to leave the relationship, and once they're in session and talking to someone like an advocate like myself, they find themselves at a loss because they don't know what to do. And so our role is to help them navigate the complex criminal justice system, getting orders of protection and all of those things. And when then they share that, this person has been driving by their home, they have been hearing voices in their home, and they're like, am I going crazy? What's happening? We learned that there's a GPS tracker. We learned that the person has been spying on them through video camcorders, and actually they would sense like there's somebody watching me. I don't understand. And so how do you take that to law enforcement? How do you articulate the hundreds and thousands of emails, flowers that are supposed to be romantic, right, and letters that are they don't cross the line of this is against the law. They're not writing, I'm going to come do X, Y, Z to you, and I'm going to do this. They're using language that only that partner knows. And it's almost like a code. And it instills fear. Just imagine, I know this is not the same level of terror, but we get phone calls and spam on our phones, and we get so tired of that, right? And we're like, why is this happening? And we just feel like, oh, so frustrated. But imagine then adding a complexity of getting these various emails and messages, and not only that, but I know what this means. This means that this person's coming after me. And I'm not here to make this a very sedacious story or shocking, but we had 2 fatalities at our agency as a result of a family member who said, come stay with us, we'll protect you. She brought her kids. She thought she was safe. She did everything right. She got an order of protection. She wrote police reports. And unfortunately, she died at the hands of her abuser. But again, how do we articulate all the various emails and texts if we don't have the teeth to actually say, after so many attempts of coming by my house and writing emails and texts, and I found this in my car, when does it become against the law and a felony?
Thank you.
I appreciate it.
Any questions?
Oh, any questions?
Thank you.
Thank you so much.
Next in favor.
Thank you very much. Derek McComb with the Kansas City, Missouri Police Department, and I would just like to go on the record in support of Senate Bill 928.
Thank you.
Thank you.
Don't forget to leave your witness form. Anyone else in favor? Or anyone else? Okay.
Thank you very much, Madam Vice Chairwoman, members of the committee. My name is Arnie C. AC Dino, State Public Advocate. At first, I was against this bill, and I've changed my mind. First of all, I want to start with the statement that no Missourian should ever touch another human being or another Missourian in a violent or a threatening manner. I believe that the 24-hour hold right now is sufficient, and I heard from the sponsor that the 48-hour is out of the bill, but then you read in the first paragraph, this act changes the period of detention on arrest without a warrant to 48 hours if a person is arrested for a criminal offense involving domestic violence.
We have a substitute that changed that.
Oh, I did not see that. Okay, great.
Okay.
So I definitely am for the bill now, if we're holding it to 24 hours, because I know many Missourians that are in a catch-shoot situation, and things are going in a relationship and it becomes used as a sword to put somebody in jail or to trump somebody up or make life miserable for them and to put them in jail. It causes employment issues, it causes all kinds of family issues. And so I'm glad to see that there's a substitute and that we're still at the 24-hour hold. I think if a judge feels it's warranted and there's violence involved, that the judge can order more time as a hold. Let's see here. I like the bill because it adds stalking, it adds tracking of electronic devices, which Representative Williams of the House has a bill, a companion bill for electronic devices. I think every Missourian should know if they're being tracked and should have proper notice if there is a tracking device. A lot of the cars, unfortunately, today that are being manufactured all have automatic GPS that anybody can, with an app on the phone, can find out where the new cars are going or where a car is parked or direction. I like that there's no contact orders and consequences if it's violated by the judge. However, when it comes to the Second Amendment, I'm a huge Second Amendment person. I think that if somebody's involved in a domestic abuse case, does not mean that they're going to be violent or use a gun. And so I want to make sure that the Second Amendment is not violated for Missouri citizens unless there's a severe or a mental issue that is brought to the court's attention. For those reasons, and thank you for amending the bill, I do wholeheartedly support SB 928. Thank you.
Thank you so much. Any questions for Zwitten? Thank you.
Thank you.
Are there anyone else to testify in support, opposition, or for informational purposes? Anyone else? That concludes our hearing for this bill. Do I have a motion to adjourn?
Yes,
second. We adjourn.
Great job.